The Constitution P 586 to 591, Kesavananda Fakirala, Palikar, J. 45. Sri Venkataramana v. The State of Mysore, 1958 SCR. 6115 and Rana Singh's case, 1965 AC 172 referred to. The decision of the majority in Goloknath that Constitution Amendment is law within the meaning of Article 13 Tar 2 held incorrect. P. 7. There were no implied or inherent limitations on the amending power under the unamended Article 368 in by its operation Otwar the Fundamental Knights Decree can be none after its amendment. King 24th Amendment docs no more than give effect to Padiyamkant's acceptance of the view taken in Sankari Prasad's case, the majority in Sajan Singh's case, and the minority in Goloknath. Lusky asked with regard to the amending power in relation to fundamental rights. It is clarificatory of the Arimnal Atide 368. What was implicit in Article 368 is now made explicit, and the ECAS and SNCC of Articles 368 is retained. Therefore, there can be no objection to the Z4th Amendment on the ground that any essential feature of the Constitution is affected, and it follows that any and one amendment of the Constitution cannot be challenged on that ground. And that would be true not only of the 24th Amendment, but also the 25th Amendment and the 29th Amendment. It may appear asri odd, yet while the framers of the Constitution did not think it necessary to expressly exclude even one provision of the Constitution from being amended, they still are. LT seended that this court, as the guardian of the Constitution, should make pay serve it unamendable by implying limitations on the amending pact. This court cannot constitute itself a guardian against change constitutional kefktel PPO 598-599. So far as the right to probe RTI is concerned, the Constitution in a Article 39B and C expressly declared its determination, in the interest of common good, to break up concentration of sort and means of production in every form, and to arrange for redistribution of ownership and control of the material resources of the community. If anything in the Constitution deserves to be called an essential feature, this determination is one. That is the central issue in this case. In a real sense, concentration of wealth in the form of agricultural lands was broken and community resources were distributed. From the conclusion that the power of amendment or inclinations unqualified by whomsoever it is exercised, it follows that there can be no implied or inherent limitations on the amending power, and where power is granted to amend the amending power, there is DQ limit to the extent this may be done. It may be curtailed or enlarged. Article 368 permits the amendment of all the provisions of the Constitution expressly, and if that power is to be cut down by something that is said in sorry other provision of the Constitution, the latter must be clear and specific. Where the test is clear, APD unambiguous, there can be no recourse to the context or the occupying of the Act, nor can the context or the scheme be utilized to make ambiguous what is clear and unambiguous. The word amendment used in the Const-JT of a Constitution is clear and unambiguous. 600 to 609J. Supreme Court Repulse, 1973. Sub-PSC 11 State of Bihar, Some Life, Kameshwar Singh, 1952. SCR 889, Rain v. Lennox, 1935. Drish Reports 170. Moore v. Attorney General for the Irish Sty, 1935. AC 484. Warburton v. Loveland, Asens at 30 Norn. Dewey Dow Clark, Sturyarandawansi, Betantki. Rotherham, 1876-77. 4 CHD 588-592. Reggie v. Burra, 1878. 3 Appy. A. 889. Attorney General Z. for the Province of Ontario, v. Attorney General for Dominion of Canada, 1912. APCAS 571. Webb, Vutrim, 1907. AC 81. The Amalgamated Society of Engineers, v. the Adelaide Steamship Company Limited Undoth S. 28 CLR 129. The Barubari Union and Exchange of Enclaves, 1960. 3 SCR 250. And Secretary of State Varfi, Maharaja of Babali, 43 Madras 529-536, PC. Referred to, fundamental rights are not inalienable natural rights. Articles 13 and 32 show that fundamental rights are rights which the people have conferred upon themselves. Even the rights conferred are not in absolute terms. They are hedged in and restricted in the interest of the general public order, public one morality, security of the state, and the like, which show that social and political considerations are more important in our organized society. The core philosophy of the Constitution lies in social, economic, and political justice, the directive principles of state.